We've had a case where a client came in with an initial offer of $10,000, and we were able to max out that claim at $50,000 for an instance.
There are so many coverage that could be applied on a single case.
We regularly refer our clients to those doctors to make sure they are well protected. Our representation of our clients do not end at settlement of the case. We go as far as making sure that we help our clients negotiate their entire medical bills and other expenses down significantly.
Hey everyone, so today we are taking interview of attorney Chuck Chionuma. He has more than 35 years of experience in the personal injury law space. So we want to ask him a few questions. So attorney, how are you doing today?
Doing really good, thank you.
So the first question which we have for you is, why should a personal injury victim never give a recorded statement to an insurance adjuster?
A personal injury victim should never give a recorded statement to an adjuster without the assistance of counsel for many reasons. Those include the fact that the things you say to an adjuster which are recorded instantaneously can hurt your case very much. A lot of things you will say in a recorded statement, such as "I feel okay," even though your injuries will get worse with the time and with the days coming through, they will always be able to go back and pull out those particular words which remain permanently on record and use it to discredit your case in the future. And whatever you say in a recorded statement, it remains there forever. It can be reproduced digitally. It can be used in any forum against your interests. And you should know that whenever you make a statement to an adjuster that's being recorded, the tendency is for you to try to minimize things. The tendency is for anybody to try to be polite and be congenial in the way they make their presentation. All those little things are used to sabotage your case at the end of the process. You should know that job is to save the insurance company money. And whatever they can find and use against you, they would definitely do it. It is their job. And that's it.
Attorney, do you have some instances in your legal experience where due to wrong statements, it negatively impacted the case? Can you take an example without, of course, revealing the names? How some of these tactics have negatively impacted some of the cases in your long career?
Oh, absolutely. There are just too many occasions where we've come across cases where in the first statement, the client tells the insurance adjuster, "I feel okay," just after the accident. Later on, when they begin to feel bad, the adjuster will go back to claim that, "No, you told us in the beginning of this incident that you were okay, but now you're claiming that you are not." Or there are many instances where people feel like they were not badly injured, so maybe I have a small headache and nothing else, and 2 or 3 days later they have serious back pains or leg pains, and the adjusters will claim, "You only had a headache, you didn't have back pain, you didn't have leg pain. That must be from a different incident, not from our incident." So those are the kind of things that typically occur in numerous cases that we handle.
Attorney, are there any tactics that these insurance companies use? Like sometimes they tell the client, "You are legally required to give these statements," but in third-party case instances, they are not legally required. So what are the instances where the client is legally required, and what are the instances where the client is exempted from giving any recorded statements?
Recorded statements are required as part of an incident investigation. The only parties that can compel you to give a recorded statement are your insurance company, because in your insurance contract, you have already agreed to cooperate with them in any investigations to determine what happened in the accident and determine their liability. A third party, which would be the person that caused you injury, does not have the right to require a recorded statement from you as part of your investigation. You have the right to have counsel present with you and to help choreograph the process to make sure that you are not taken advantage of. You should never go into a recorded statement with a third-party insurance carrier if you do not have counsel present with you.
Yes. So, yeah, that's very good explanation for this, attorney. So let me move to my next question here. Yeah, Attorney Chuck, the second question which I have for you, how is good documentation very important for the personal injury cases? And how do you recommend your clients to the specialized doctors who are specialized to treat the injury victims? So how does that medical process works?
That's a good question. The documentation in terms of the facts of the accident, the facts of the case, the injury itself, all those layers of documentation are essentially very important in the case because that constitutes the evidence that is going to be presented to support whatever claim you're making regarding your injuries. It is also very important to make sure that you get to the right kind of healthcare providers that will provide you the right treatment for your particular injuries. To give you an example, if you visit a general practitioner, for an instance, and complain of back pain, most likely you may receive some medication and sent home for the day. And that may not be the best way to treat you. The known protocol for treatment of physical injuries are best attended to by orthopedic practitioners or people in physical therapy who would actually know how to deal with those models of injuries and document it appropriately in a way that insurance companies can understand and in the way that your lawyer can use in evidence to present your case at trial if need be. That's really very important to make sure that you are in those type of places. And good lawyers, good law firms have knowledge of what doctors in their vicinities, like in Kansas City, for an instance. I know what doctors in my area that are very good and have the specialty to be able to provide this kind of treatment. And we regularly refer our clients to those doctors to make sure they are well protected.
Yeah. So, attorney, how does the doctor's recommendation affect the case? For example, if the doctor is recommending that some future treatments or surgeries might be needed, so how would that affect the case?
The doctor's recommendations affect the case very much. It increases the value of the case depending on what the doctors find, because their recommendations are typically based on objective findings of injuries, which they document and make available for any other person to see and confirm that is actually an injury that exists. Even if the patient does not immediately submit to the surgery that is recommended, assuming that the surgery is recommended, we know that there is an injury underneath that. We know there is an underlying injury for which that patient is continuing to suffer pain on a consistent basis until the surgery is performed. So overall, it increases the value of the case, both to the jury and to the insurance company.
Attorney, are they required to proactively tell the doctors that these pains are specifically from the accident, or these doctors they are already assigning those pains specifically to those incidents?
So it is very important that the patients tell the doctor what happened and where the injuries are and everything that they are experiencing. I always tell my clients, make sure that you tell your doctor everything that you're feeling regarding the injury because of two good reasons. One, if you tell them the right thing, they will provide you with the right treatment so you can get well quicker. And secondly, they will document it as they are trained to do. And that documentation becomes the evidence that I'm going to use to secure the most value for your case. So if you have headache and you do not tell the doctor, he doesn't treat you and he doesn't write it down, at the end of the day, I can't prove that you have the headache. So communication with your healthcare provider and compliance with their recommendation is essential to preserving the value of your case and also your health.
So, attorney, how do you make sure that the client, their injuries are related to the accident? Because the insurance companies, sometimes they might argue that these injuries are not related to the accident. So how do you make sure that everything is in place?
That is a very important question. The doctors are the ones that are able to make that causal connection. So communication with the doctor is very important, because at the end of the day, what the doctor finds medically is what we can present to the jury if we have to try the case to establish a case. So again, communicating with the doctors very candidly and very consistently is the best way to make sure that you preserve it for future presentation.
Yeah, attorney, sometimes it happens that the clients, they prematurely pause their own treatments. So what is your recommendations to such of the instances? For example, sometimes the clients tell that, hey, I am feeling fine for now, but after a few weeks, their pain re-emerges. What is your recommendation as a legal professional to the clients who sometimes take the medical treatments in their own hands?
It is really very important to make sure that you follow the doctor's instructions. For one, to make sure that you get well and avoid the circumstance where you have a reoccurrence and then you are stuck with inability to pursue any further claims. The law requires you to mitigate your own damages, which means do everything that you can to get well fast and quickly enough so that you don't incur liability or future. The law requires you to mitigate your own damages, and that means to do everything reasonably within your powers to get well as quickly as possible. When you fail to do that and any complications occur in the future, that becomes your own liability. You cannot go back to the person that caused the original injury and say, yeah, now I have a complication. It's from your incident, when you could have done the right thing that your doctor recommended in the first place to get well and avoid that issue. So following your doctor's instruction is essential, not only because it makes you get well faster and better, but it's also required by law to keep your injuries from becoming complicated and creating more problems down the line.
Yeah. And attorney, how does the time from the accident till the treatment, how does that affects the value of a case? For example, sometimes we receive calls from accident victims after 6 months of the accident. At the time of the accident, they had gone to a few emergency centers, but after that, they had not pursued their treatments. But after 6 months, they are calling because they are feeling some pain. So how does that affect the case?
It affects the case very much because it allows the insurance companies to argue that the pain you're feeling today may not be related to the incident that happened 6 months ago. They will argue that many things could have happened in between that time, and also argue that if you really had a problem, you should have gone in the first place to the doctors, to the hospital, and getting treatment. And your failure to do is now, your problem going forward. So again, you need to take care of yourself at the beginning and get all the right treatment that you need. Follow instructions.
So, attorney, has it happened over your vast experience that sometimes the personal injury victims, they don't have the funds to get treated, but you have helped them because you were able to refer them to doctors who can lean against the settlement? Can you take a few examples about some major cases which have happened over the course of your career?
Absolutely. We have a lot of cases of that kind where clients will come in, they don't have health insurance, they don't have the money to pay upfront for their treatment. And we know doctors and facilities that are able to provide those treatments without upfront charges and wait until the cases are settled before they get paid. And they work on lien, L-I-E. And that's a legal term under which they are able to get paid at the end of the case without causing unnecessary discomfort for the client in the interim. Getting to a good lawyer that knows the right clinics to go to is very important in the beginning of your injuries so that you can get treated and get well as quickly as possible.
So, attorney, how do you help clients who, because of their medical treatments, the bills that have piled up, they are a huge and sizable amount because of the injuries and the medical treatment that they have gone through in the process. So how does your law firm help for these clients?
Our representation of our clients do not end at settlement of the case. We go as far as making sure that we help our clients negotiate their entire medical bills and other expenses down significantly so that they will have significant recovery in their pocket. If need be, we will apply the Missouri lien laws, which requires lien holders to come to the table with us and again reduce all their medical bills pro rata, such that the client will have at a minimum 50% of the proceeds after attorney's fees from the settlement. So we make sure that our clients have good recovery in their pocket at the end of every case, regardless of the amount of medical bills involved.
So attorney, how do you manage to do these negotiations in the behalf of your client when it comes to negotiating with the medical providers?
I have a staff that does nothing but negotiation with all the providers, and they have very good experience with negotiations. And again, when required, we will step in with the lien laws and bring them to the table and make sure that they comply with the laws so that our client will have a good recovery at the end of the day.
Yeah, attorney, like apart from the laws, does your reputation, like being in the market for so long and have a very good connections with these medical providers, does it also help in the negotiations part of the thing?
Absolutely. With doctors that know us and have seen our work in the past and know that we do work very hard for our clients, they very quickly work with us. They come to the table without coercion and negotiate and resolve the deals at a reasonable rate so that our clients will have good recovery at the end of the day.
Yeah. Attorney, based on your experience, like how often do you think that the insurance company actually offers a fair amount for the first offer that they generally give the clients?
Hardly ever. Let me tell you this, as an attorney, I have represented insurance companies, I have represented major companies in defense cases for many years before I became a plaintiff's attorney. And I know from experience that it is never done that your first offer is the best offer you can make. They don't do that. The typical thing is they assess what the case is worth and they offer you way below that amount and hope that you will take something close to that. And the more money they save for their employer, the more promotion they get, the more they look good to their employer, the insurance company. So it never happens that they do that. They will all offer you less than your case is worth.
Yeah, attorney, can you take a few examples where it happens sometimes that the first offer was way below the actual settlement amount that you got? Like any example which is on the top of your mind?
Yeah, there have been so many of those type of cases. We've had a case where the client came in with an initial offer of $10,000 and we were able to max out that claim at $50,000 for an instance. Those are very common occurrences. And again, it's always the case that they will offer you lower than your case is worth to begin with.
Yeah. So, attorney, how do you help the clients to find out all the insurance coverage that is being applied in that particular situation? For example, there are many type of insurance that are applied for the same case. Some uninsured motorist coverage, commercial coverage, or public property coverage. There are so many coverage that could be applied on a single case. So how do you help the client to discover the value of all the coverages that could be applied in a accident case?
That is part of our routine. Any good attorney will have an understanding of how they conduct their investigations, where to look for those policies, where to look for liability, and aggregate all of those items together and look for the best ways to increase the value for your clients. Without doing that, then they are not doing the appropriate work that they are supposed to be doing as an attorney. As a law firm, we again have all of our processes put together and we know where to go start looking as soon as we get the case in.
So attorney, has it ever happened in your experience that you got to find out some hidden insurance policy coverages which were not apparent from the beginning of the case, but you were able to find out after deep diving into the case, and how does that pan out?
It pans out in too many different ways. There are instances where we find out that there are other people that have liability to the client for the same accident, and we'll bring in their policy to the policy of the primary tortfeasor, being the primary person that caused the original injury. And that will increase the value of the case for the client. There are instances where after exhausting all of the available policies, we'll go to the Tort Victims Fund under Missouri law and collect more money for the client. And those are areas where typically people do not know exist. Even some lawyers don't know those exist. But we find those avenues of recovery for our clients and make sure that they get the maximum value for their case.
And attorney, like, how does your willingness to go to trial impact the settlement that you are able to get for your clients?
Every lawyer's reputation is very important in their vicinity, in their areas of practice. When an insurance company knows that your lawyer does not go to court or is afraid to go to court, then they are not convinced to offer the most value for the case to avoid going to court. When your lawyer files a lawsuit on your behalf, then the insurance company has to hire a lawyer and pay the lawyer, and the value of the case now begins to go up for them because they are incurring more costs as the days go by. So our willingness to file a lawsuit enhances the value of the case for us because the insurance company knows that we are serious and we will go to war if need be to protect our clients' rights.
Has it ever happened in your experience before, like even the draft lawsuit, like it increased the settlement offer?
All the time. In fact, there are insurance companies that have people or on investigators who are watching the court dockets to see who filed a lawsuit. And once a lawsuit is filed, they will immediately call up the lawyer and say, hey, can we talk? Here's a little bit more money, let's get this resolved, so that they don't have to go pay another lawyer to come defend the case. We get that on a regular basis. As soon as we file a lawsuit, we'll have a call from the adjuster. Can we talk, please? There is some more money on the table. And that way, the client gets more money in that process.
So, attorney, how often do you do things like that filing for these draft lawsuits, or sometimes even negotiating very hard with the insurance companies?
We file lawsuits on a regular basis. Last week, for an instance, I believe we probably filed about 4 or 5 petitions. Whenever we reach an impasse with the insurance company where we don't believe they're being fair to our client in terms of how they are valuing the case, I will immediately file a lawsuit and take it downtown so we can go resolve it there. And in fact, after this interview, I'm heading to court on a case that we just recently filed.
Best of luck for that, attorney.
Thank you.
So the next question is, if the adjuster is saying that in the emails, even on the phone calls, that, hey, this is the final offer. So is it really the end of the negotiation, or there is still room for negotiations after that?
There is always room for negotiations. They have final offer unless they have reached the maximum policy limit, there is always room to negotiate.
So the next question is the settlement that the personal injury victim is getting on the end of the day, is that taxable?
In most cases, not, but I always advise my clients to check with their accountant.
Okay. So Adani, is there any clauses where if the client is signing any confidentiality, then in those cases it would be taxed, otherwise it might not be taxed? So are there anything specific that you have come to your mind?
Not that I'm aware of.
Yeah. The next question is, Adani, how does permanent injuries like scars or burns or bone fractures, how do they affect the value of the case?
Permanent injuries such as scars or broken bones affect the value of the case positively because it presents an objective evidence of what happened to this person. And a scar, for an instance, lasts indefinitely, and that becomes a value on its own that the insurance company has to take into consideration in determining what to pay for the injuries. If it goes to trial, the jury will also see that and see that it is something that this person is suffering or will continue to suffer indefinitely. That also adds value to the jury as to what to award that person for those injuries.
Attorney, what happens if a client is partially at fault, for example, 10% or 20% at fault? So how do you navigate those kind of cases, and what would be the recommendations for clients?
When our client is partially at fault, we still go forward with the case. We do understand that there would be a deduction for the percentage of fault our client is determined to be in. However, our job, in addition to driving up the value of the case, is to minimize the percentage of fault that our client is being found, and to make sure that at the end of the day, our client comes up with more value.
So, Attorney, how do you normally reduce the fault of the client, and how do you argue with the insurance company about this specific topic?
Those are usually very fact-intensive. You go to the facts of the case and see the sequence of events and how everybody's role combined to cause the incident or the crash. You will now be able to see who had the last chance to avoid this incident, what was my client's role in it, how my client's role was not as severe a fault as the other person's, and argue very vigorously to show that. Look for evidence to support your position. There may be video recordings out there. There may be street cams out there. We go out and we look for all this kind of evidence. There may be witnesses that will support our position. We'll find them and bring everybody to the table, bring all the evidence to the table to show that our client was not as much at fault as they're being accused of.
So, Attorney, what is your recommendations to your clients when it comes to keeping a track of their photos and the videos from the injuries and as well as the treatments? So what is your normal recommendation that you always tell your clients to do so that the record is being maintained and it could also help in the case?
We always advise our clients from the beginning of the incident, make sure you take as pictures as possible. And once you have your lawyer, transfer those files to the lawyer's office immediately so that they can be preserved. Take pictures of the injuries while you're healing on a periodic basis so that we can see the progression of the healing process. Take pictures of other people's license plates who were around there when the incident happened. Pictorial evidence is very important and will help us do the best to prosecute your case appropriately. Without those kind of evidence, a lot of information will be lost and cannot be recovered with time.
So, Attorney, what do you do for some cases where the client is too much hurt and they cannot come to the office and they are in the hospital or they are bedridden? So what are the specific facilities that you provide for such clients?
For those kind of clients that are unable to come to the office because of the extent of their injuries, we go visit them on invitation. We go help them with whatever is needed in terms of gathering the evidence that's needed to preserve their case. If need be, begin to take those pictures that we suggested earlier and preserving those for the client, of course, with their permission and their consent, so that again, we can be able to help them maximize their case as we go forward.
Yeah. So Attorney, sometimes the client, they are very stressed about the notion that they have to visit the courts if the case is going to a trial. So what is your normal recommendations for such clients who are very stressed about these things and they have never experienced such things before?
Trial is stressful for everybody. So we want to make sure that our clients understand that in the beginning and use that in factoring what direction we go in the case. We don't go to trial without our clients' complete consent and participation. So that's, again, very important that we make sure the client is comfortable with the process. We sit down, we show them exactly how the process works. We make them understand it's a civil matter. It's not a matter that requires jail term or anything of that nature. It's a question of coming, telling the truth, presenting your evidence, and letting the jury, the judge, make their determination as to what the value of the case is. And basically, most clients find that an easy process once they understand what is going to be happening in the process.
Yeah. So Attorney, how often does Chionuma Law give updates to their existing clients when you are taking on their case and they are in the negotiation process? What must be the client's expectation?
We make sure that our clients understand every step of our negotiation process. When the case originally comes to the office, we sit down with the client and go over the entire case and how we're going to be pursuing the claim. We make sure they understand that the recovery process has to be completed before we move forward in terms of trying to settle the case. In essence, we can't settle the case in the middle of them receiving medical treatment because we don't know what the entire treatment is going to entail. When the treatment is complete, we normally sit down with the client and go over all the providers that they have seen, make sure that everybody's on the same page, that nothing has been missed. We show them our tabulation of all the damages and make sure that we haven't missed out on anything before we submit our demand to the insurance company. And when the offers come in, we inform the client and go step by step with the negotiation process until the case is resolved. Then we also make sure we inform them of all the other negotiations we do with the providers to make sure that we reduce their medical expenditure to the point where they're comfortable. So we work with our clients all through the process to make sure that they are well informed.
So Attorney, there's a very common question like, does getting settlement from these insurance companies, would it in any way impact my premiums for the car insurance that I would be going to pay like after this time?
No, it doesn't. The only thing that will affect your premium is whether or not you were at fault in causing the accident. That's what should affect your premium. If anything else does affect your premium, there are thousands, if not hundreds, if not thousands of other insurance companies that you can go to and get another quote and move on to another company. So refusing or foregoing making a claim because you think it will affect your policy is misguided.
Yeah, it's a normal fear that people have that these companies, like, they might come after me after all these things are said and done.
Okay, getting close.
Yeah, Attorney, some last questions. Can I reopen my case if new injuries or complications are arising later?
If you have settled your case, no, you cannot reopen your case. And that is the reason why we want to make sure you are completely recovered and released from medical treatment before we begin to negotiate your case. And once you resolve your case, you can go back.
I've covered most of the exhaustive, and I would be creating many videos out of it. I think I would be done for the month. Yeah.